That was great, and we're going to continue on in this next panel talking more about open source and copyright. So I want to first introduce our panel moderator, Professor Russ Altman. Russ is the Kenneth Fong Professor and Professor of Bioengineering, of Genetics, of Medicine, of Biomedical Data Science, and by courtesy of Computer Science. He's also one of the associate directors of Stanford HAI, and when I met Russ, I felt my long-lost brother, so thank you, Russ.
Thank you, James. This session is called Generative AI, Issues in Art, Copyright, and Open Source. So what's more natural than having a bioengineer faculty moderate it? So I'm really happy to briefly introduce Scott Draves, who will speak first. He's an AI artist and engineer. And Pam Samuelson will speak after Scott. She's a professor of law at Berkeley Law School and co-director of the Center for Law and Technology. So with those brief introductions, I'll just throw it to Scott.
Thank you. And thanks for all your attention this morning. It's an honor to be here. So a lot of people have a take on generative AI, and before I give you yet another one, just where does mine come from, and where do I come from? And I was trying to think of what I can best contribute here today, and I thought one thing is just where does generative AI come from? What's the history here? And so this image, here's an example. I've been doing this open source and generative art since the 80s and 90s. And this image is flame number 149 from 1994, where it got an award at the Prix Ars Electronica, and is really what made me realize I was an artist before that was, and this was perhaps the first open source artwork, and was really very much, it wasn't just an image, it was code that allowed other artists to create their own images. And this artwork was very much about enabling other artists and the sort of meta interactivity of programming, exchanging code over the internet, and building things together. And so this flame algorithm, as it became known, created a whole genre and visual style. And eventually I couldn't even go into a bookstore or look at a magazine rack without seeing some version of it. And of course, so, there we go, here we go. Here's an album cover that used it, and of course, these were all images. I didn't get any sort of credit for this. My name isn't here. It was made by another artist just using the algorithm. And really, what I learned from this was, I put this code out there with a plan, but what I learned was that sort of giving up control. The real power isn't sort of getting what you want, getting other artists to use it or to contribute, to give me code back, but really getting things that I didn't know I wanted or I didn't want, and enabling other people to do things that were really unexpected. And so just in 1999, the Electric Sheep I created this infinite evolving AI screensaver, which used feedback from its audience. And so it learned from everybody who was watching it, and it tried to satisfy that human desire. And it generated animations, excuse me. And this was a collective intelligence created 24 years ago and actually still running. And so this image, sorry, here we go. And so this image is actually a still frame from a Super Bowl commercial that IBM and H&R Block ran. So it definitely went places that I didn't expect and didn't plan. But for most of my career, I was a regular tech guy. I got a PhD in computer science with James, and worked on regular technology, and unrelated to. But I had an interlude in my career for 5 years. I worked full time as an artist, just doing open source stuff. And I'll show one more much lesser known example here of my sort of talking about history. This is sort of like a super early attempt at something that is now like Stable Diffusion. So this is a generative algorithm that takes an image as input and sort of and generates stuff that looks based is modeled after the inputs. And so, as you can see, here's an attempt at doing hands. It still has the same problems after all these years. Oops, sorry. There we go. Yeah, this was 1993 though. So all these were all predate the adoption of neural networks we have today. So, but that's So that's sort of where I'm coming from as somebody who's been doing this the open source stuff and the generative AI stuff, and learned about it. But it's all just prelude to what's been happening these days, and so and it's child's play compared to what the algorithms today are doing. So over the last 3 years, I've seen an incredible leap in the computer's ability to understand human language and generate images. And so what are the implications of this? I would say we could have like a private tutor for every child, a personal assistant in everyone's pocket. New forms of personal expression, Photoshop that's easy to use and just does what you tell it. Interactive fiction, who knows? These are just really like the obvious ideas, some of them from fiction itself. But, like, say, George Méliès, we're really just at the beginning of this. We're still pointing a camera at a stage, and we don't know what's really going to take off and where this technology is going to take us, and what its unintended consequences are. And these models, language models and image models contain notions of truth and beauty, but who defines truth, and who defines beauty? And how can you trust that the model that you're using serves your interests versus, say, the company that created it? So the models that have been sort of making headlines are proprietary products from secretive organizations, and there's issues with trust and accountability. So. But the good news is there's an alternative, and that's open source. So, and there's four parts to that. We need the code for training the models to be open. We need the code that runs the models, the inference engine, to be open. We need the training data to be open, and the model weights to be open. And if we have those four things, then what are the implications? If you can see the data that goes in the models, that allows independent research and third-party audits, and it can really help with the trust and alignment, because you can find what's how you can really see how it works. And the liberal licensing, because open source makes stuff free to use, and that's going to really help spread the benefits of AI to everyone. And if the licensing is liberal, which means like allowing commercial use, then that can motivate investment. I mean, you can get like a virtuous cycle of improvement. And it's really important, though, that one of the things that open source enables is this forking and fine-tuning of the models. And so you can take a foundation model and add a little bit more data and, change its character and change its notion of truth and change it. And that allows, each person, or for every country or every culture or every identity, to create their own models. So instead of having just one model from one company, you can have each person or each organization or each group of people, creating their own model. And, we're really lucky. The beauty of these pre-trained models, the foundation models, is that making them is extremely expensive, but the fine-tuning is actually really easy and cheap. You can just do that in a few days. And so, so instead of having, one notion of truth, we can have, freedom of choice. And, bias, I think, is really inherent in the model, so we need to just be able to do the one we want. And ultimately, every person can have, their own model. So I think that open source will help a lot with a bunch of these sort of hard problems. But there's really one that remains, which is what happens if these powerful tools are used by people for, say, nefarious purposes. And, the harm can result. And there's really, I think, ultimately, I'm optimistic about this. And, if you look at the history of technology, I think ultimately I believe in human nature, and that there's more good people than bad people, and the benefits outweigh the problems, and we will identify the problems and address them, the best we can as the cookie crumbles. So, and my experience is that open source is part of that solution of making this technology work best for everyone. And so that's the end of my introduction. Thank you.
So good morning. I'm very happy to be here. Thank you for the invitation. Copyright challenges to generative AI is the focus of my talk today. We could have a really long conversation about the governance challenges generally that generative AI is posing. There's a global conversation about this particular topic. Obviously, the general public has embraced ChatGPT and many of these systems that you read about in the paper, and a lot of technologists are enthusiastic about it too, but policymakers are concerned about everything from privacy and cybersecurity, defamation, disinformation, just to name a few. So we're just going to talk about copyright today. And a thing to know as we begin this is that some authors, artists, and programmers are very positive about this development and about copyright as not being an obstacle, and others are very negative. There are 3 lawsuits right now challenging generative AI on copyright and related grounds. The United States Copyright Office is holding some listening sessions about stakeholders' interests in how the Copyright Office should be thinking about the main issues that it is addressing, and it will publish a report probably sometime by the end of the year. And the Copyright Office actually has a website that's all about generative AI. And so lots and lots of materials there if you're interested in it. I'm going to only have time to talk about 3 questions, and I'm going to have to do it really fast. The question about whether ingesting copies of copyrighted works as training data, is that an infringement of copyrights in those works? Obviously, pretty much everything that's out there on the open web is actually protected by copyright law, unless it was authored by the US government. And that means that there's a lot of copyrighted stuff out there, even if people aren't exploiting it in the way that that many of the copyright industries do. The works are still protected. And then a second question is whether AI-generated outputs are infringing derivative works of ingested content. 2 of the lawsuits against Stability raised this issue as well as the first one. And then a third question has to do with removal or alteration of what copyright law calls copyright management information, things about sort of what is the name of the work, who's the author, and on what terms it's available. And the Stability cases raise this issue, as does a class action lawsuit against GitHub and OpenAI over the Codex large language model and Copilot, the programming assistant tool that Microsoft is hosting in the cloud. The briefest thing I can say about copyright is that it attaches automatically by operation of law from the first fixation of a work in a tangible form. And the author is the one who gets those rights. And these are the 5 major exclusive rights that copyright grants to them. The rights last for practically forever. And copyright only protects the original expression of an author, not the ideas, not the facts, not the methods. There are lots and lots of unprotected stuff in copyrighted works. And copyright's exclusive rights are limited by fair use and various other doctrines. And there's a special copyright-like law that makes intentional removal or alteration of copyright management information illegal if you know that it will facilitate copyright infringement. Fair uses are non-infringing, so it's a defense to a charge of infringement, and fair use is usually the defense that's raised when we're talking about the ingesting of copyright works as training data, and there are various factors. I'm not going to be able to go into this right now, but I'm certainly happy to talk at the break about these things. So is ingesting works as training data copyright infringement or not? There are at least several cases, and I'm listing 2 of them here, where the court basically threw out copyright claims on fair use grounds, so that Field put a bunch of his work up on the internet. Google, of course, crawls the web and copied it to index the contents and to let people find Field's work. And Field said, that's a copyright infringement. And the court said, no, it's fair use because Google is using the works not to exploit the content, but to just let people know that the works exist and are out there. And in the Authors Guild versus Google case, an appellate court ruled that Google's digitization of tens of millions of in-copyright books from research library collections was fair use when it was done for the purpose of indexing the contents and serving up snippets in response to search queries. So Stability is going to be relying on these and similar cases is to support its fair use defenses. But there are a lot of people out there who really don't like the ingestion without permission, and they can't really easily opt out. They weren't paid for the value of their contributions, and some part of the concern is that the images that are being generated through Stable Diffusion and others of these images generators is that they will compete in the market with the images that artists actually are doing, and it's in some sense you're competing against yourself in some sense, or at least that's the way some of the artists think about it. And this cartoon actually is kind of illustrates how some people think about generative AI. Now, there are countervailing considerations. Generally speaking, the people who develop these large language models are not really interested in the original expression in a work. They're really interested in essentially understanding the facts, and they kind of think of documents and the like as raw material for computational uses that are actually not exploiting the expression. And so that's sort of a way of kind of looking at it. And also, generative AI enables a lot of creative reuses of things. And so what copyright law is supposed to be doing is promoting the progress of science or knowledge and culture. And so the people who favor generative AI are thinking that this is actually a good thing, that generative AI advances the purposes of copyright. Outputs as derivative works. So authors have exclusive rights to prepare derivative works, but the courts have basically said something can't infringe the derivative work right if you haven't just extracted some expression from an existing work and then put it into a second work. So it's not enough just to be based upon an existing work. You actually have to have essentially taken expression and reused it. And the class action lawsuit against Stability claims that every output of Stable Diffusion is an infringing derivative work, and I think that's actually hard to say under existing precedents that that's a sound result. But in general, the text and images that are generated in response to user prompts are not going to be substantially similar in their expression to the works that were in the training data, and if that's true, then that's unlikely to infringe the derivative work right. You know, there are some examples that people have shown where you can essentially like Mickey Mouse and Superman, you do a prompt with them, you're going to get an image that's going to look like Mickey Mouse or Superman. Of the cases against Stability, Getty says, hey, Stability, you ingested 12 million photographs and captions from our online database. That's actually copyright infringement. Also, you know, there are some images they claim that are infringing of the derivative work right, and also there's a copyright management information claim in this particular case. And here's an example. I don't know whether you can see it, but this is Getty Images, and this is the mangled stuff. And so that's a basis for claiming that there is that Stable Diffusion is at least violating the copyright management information law. And so with that, you know, these lawsuits are in very early stages. It's going to be many years, actually, probably, until we know what the results are from the courts. But it's actually good to remember this isn't the first disruptive technology that's ever been out there. I like to remember that piano rolls were a disruptive technology of the day because the composers basically said, hey, that's my music, but it didn't look like a copyright infringement to the courts. And so it went up to the Supreme Court, said, no, it's not a copy because it's part of a machine. So copyright law has had to evolve to kind of recognize that, that technology has to be responded to, and sometimes you amend the law in order to protect copyright owners, and sometimes, you just let the technology happen. So, the recording industry hated MP3 players, but guess what? They're legal. So anyway, I'll just leave that with for discussion, and thanks very much for your time.
So I think we have microphones for questions. So if you want to raise your hand, I'll start things off. Thank you both for those really stimulating comments. You referred to a bunch of lawsuits that are ongoing. And I was wondering, is that how this is going to play out? Is it going to be the courts that figure this out versus kind of a prospective, either regulatory approach or self-governance by the companies that are involved? And I'd be very interested in both of your thoughts about those alternatives to just having the courts make these decisions and using those precedents.
Well, the Copyright Office, as I said, has a clear intent to put a marker down in terms of the sort of the major questions that I was just raising, and so they'll have a say about.
Do they have a good history of moving?
No, but they have motivation. They can't do anything by themselves, right? They can make recommendations to Congress to pass legislation, and we all know how functional Congress is right now. So, part of what happens is that when you have a dysfunctional Congress, and the Biden administration, whatever they might think about this, they can't do anything either. Okay, so lots of things end up in court because there's a big dispute and there's no other entity that really can deal with this. I should actually mention that one of the things that is important is that fair use is a limitation on copyright in the United States. There are a number of other countries that actually have fair use defenses in their copyright laws too, but most of the other developed countries have special exceptions for text and data mining. And so at least for the purpose of ingestion of copyright works for generative AI, the text and data mining exceptions would actually kick in. And at least for scientific and nonprofit uses, that cannot be overridden by contract. And right now, there's a question about whether people can opt out. I remember the discussion on the first session about opting out. And it's not clear you can opt out.
So Scott, on the same issue, you had the 4 key tenets of open source: code open, inference code open, data open. And I wonder if you can comment on the data open. I just wanted to hear a little bit more about how open and how this interacts with your thoughts about copyright. And
Sure. When I say the data open, I mean that all the list of images or texts, all the documents that are fed into the training algorithm is a published list that anyone can inspect.
There's actually a proposal in the European Union that, as part of the AI Act that they're considering, is to have a requirement that generative AI systems have to disclose what copyright works they ingested. So that's kind of consistent with your kind of preference for open data in that way.
Yeah. So, and then once, if you have a list, you can look and see, are you on it? And copyright law is certainly too complicated for me to understand. I have no idea, what's going to happen. And but I do believe that there is, some list of, there's tons of public domain imagery out there. There's tons of information out there. There's all kinds of licensing available. And I believe there is a list of data. There is a data set that would be sort of useful and legal, and we should pursue it together. So let's look at the list and come up with a consensus.
It's actually also important to know, especially for any of you out there who are trying to develop some of these models, that Creative Commons' official position is that using Creative Commons works as training data is actually not a violation of the Creative Commons licenses. Now, this is in contrast to the GitHub lawsuit in which the 4 programmers have sued GitHub, OpenAI, and Microsoft for breaching open source licenses because the generative system that was built on top of a model that was ingested the open source code is actually, they're claiming it's a breach of license because there's no attribution, right? And so that's actually an issue that where they at least taking that position. Now, again, who knows what the courts will do with that.
I did want to take some questions from the audience. Do we have, I saw this hand first.
Thank you very much for your thought-provoking comments. One of the points you made were about truth and beauty, right? Truth, coming from a scientific background, you kind of think about it as objective evidence, something which is backed by objective evidence. But beauty is more subjective. It can be interpreted by the eye of the beholder, right? So can you elaborate on that in terms of how can we make sure that we don't get into the world of alternative facts, but maintain one notion of truth if it makes sense?
You know, there's certainly scientific truth is maybe the easier part. Like at least we have like you know, the scientific method that we have a way that we can agree on a process to figure out what that is. Obviously, it's executed by people and imperfect. But there's you know there's all kinds of truths. You know, there's historical truths, and there's you know personal truths, and I just really don't see us coming up with a single definition for that. And so that's why we need, you know, the ability for people to fine-tune their own versions of the models and ultimately, define their own truths. And yeah, those could be, if you disagree with them, you might call it misinformation or alternative facts, I think. You know, but I just don't see any way of, regulating a single answer there. And I think it's better to, allow, diversity of those terms, diversity of truth and beauty. That's my position.
We have 1, 2, and then if we're really lucky, 3.
Thank you so much for your comments. I have a question that sort of touches on both aspects of generative AI from the artist perspective, as well as when you look at copyright infringement. And so I don't know if everyone is familiar with the new trend of music covers by generated AI machines, but more so coming from the consumer listening to a piece of music and wondering what it would sound like if a different artist sang it. And I know Universal Music put out a statement saying they would pursue legal action against those types of music covers. But when another human makes a cover of a musical piece, it's not illegal, right? They have the right to creatively express themselves on a piece of music. And so I'm wondering from the artist's perspective as well as from a legal perspective, how can we, or is it even possible to regulate this intersection of generative AI meets consumers that are paying to have access to certain types of music, as well as copyright and intellectual property from the artist's perspective?
Yeah, can you add?
It's a great question. We do have a panel in the afternoon that addresses that too, so thank you so much for that great question.
Well, I think that to the extent that some software tool enables people to do their karaoke as a kind of generate the music that you want to hear. That's going to be something that Universal probably won't know about and won't care about. It's kind of like fan fiction kind of stuff, which mostly has been either considered fair use or been tolerated by people. But you try to go public with that. You try to commercialize it, and Universal, I guarantee you, Universal will be there. And one thing that actually is going to be, I think, more significant in the generative AI space than it has been in other contexts, and that is right of publicity. So there is this law, it's really state law, which basically says that people have a right to control the use of their names and likenesses for kind of commercial purposes. So if somebody takes a picture of you and then uses that as an advertisement for some other product, that's actually a violation of right of publicity. And that the Drake song that went viral is something where I think there was a right of publicity issue in that case. I mean, it didn't turn into litigation because it just got taken down really fast, because I can tell you that Universal makes its voice heard really loud with anybody that's hosting stuff like that. So it got taken down pretty fast, but it went viral really fast too. And it's certainly not going to be the only time when a sample of someone's voice is used to then make music that sounds like that's them when it's not. So there are also laws against false representation, and so there are kind of some existing laws other than copyright that may have some bearing on that.
We're now entering the lightning round.
Okay. All right. Really quickly, I really appreciate your response, Scott, to the question about scientific truth, and I think it's really important to push back on this privileging of scientific truth, because I think from this audience, it's just as ambiguous as the definitions of beauty. I wanted to ask you quickly if you've been really unique in giving away a huge amount of your work, and even without asking for credit or attribution. So I'm curious if you have any regrets or advice on that. And really quick to Pam, if we have time, but has this recent Warhol versus Goldsmith's decision changed anything in regard to AI?
I don't have any regrets. I mean, I've lived a charmed existence. I've been incredibly lucky, and it's hard to untangle, like what would have happened. But so I think it's working great. I would recommend it, and yeah, I don't know.
Let's go to the next one. Thank you. I'm sorry.
Warhol.
Yeah, go.
So, short version, the United States Supreme Court just decided that that a commercial license of an image that Andy Warhol created in 1984. So the commercial license in 2016 was not a fair use of that image. They didn't reach the question about sort of how far and whether the works, when they were created, were infringing or not. They just basically said that Goldsmith had abandoned those claims, and so really, really narrow issue. A commercial license of that particular image. Court didn't say it was necessarily infringing, but said that it wasn't a transformative enough use of the image. So, there's some dicta in that opinion that a lot of people who hate fair use are going to just love, but for the most part, really narrow ruling.
We do have some questions from the audience remotely, but many of the issues have at least been touched remote and glancing blows.
I wanted to just ask you, Pam, just to speculate, or sort of what your assessment is of the viability of a fair use claim, given that the fourth factor is maybe increasingly in question since the AI companies now have created this booming market for data, and the value of that data now is sort of widely recognized, and a lot of companies who have access to a lot of data are creating licensing agreements for the use of that data in training AI. Does that change your, guess, I guess, about how courts will fall on the fair use question?
Well, I think that Getty Images lawsuit against Stability, that's a more kind of important consideration because Getty Images says I'm completely happy for you to use my images and the captions as training data, but I have a licensing program for that, and so it's not fair use. The class action lawsuit, I think, is quite a different thing because the three artists that claim to be the class plaintiffs are trying to represent all of the artists of all the visual images in the world that were ingested. You can't get a license there. So it seems to me that the fair use claim is going to be stronger where it's infeasible to do it. I don't know that the existence of, look, every time somebody brings a lawsuit, they're basically saying, I have licenses, okay? Or I'm willing to license this particular thing. So the fact that you want to license, the fact that you have a licensing program, doesn't actually necessarily mean that it's not fair use. I am not going to predict here, but certainly the Getty Images case has a stronger response to the fair use claim than the Anderson class action case.
Well, I want to thank the panelists and thank for the questions.